Proceedings are resumed. Recognize the member from Northside.
Madam Speaker, I suggest we move on to the next item of business. Oh, okay. Oh. In that case, I have a supplementary.
Recognize the member from Northside.
Through you, Madam Speaker, can the minister say what kind of survey was done by the Water Authority to determine that this specialized equipment was not available on the island and idle at the time?
Honorable Minister for Infrastructure, the member from Northside wants to find out what type of survey was done for the specialized equipment.
Madam Speaker, the simple answer and the truthful answer is I don't know. The fact of the matter is that I knew nothing about this situation until the question was asked, because no application had come through the ministry for the importation. The Water Authority has said, out of ignorance, they didn't know they had to apply because this equipment was being, in other words, it was a temporary importation, it was being sent back. That's what I understand. I also understand at this point in time, Madam Speaker, that there are those within these halls who are of a firm view that such equipment is available locally. So I have already instructed two things to the Deputy Chief Officer. First of all, to send around to all of the agencies, advising them that even when it's temporary importation of any heavy equipment, that they must apply to the ministry with accompanying justification so that the ministry can check it out. In this instance, the ministry simply didn't know. And the other thing that I want to find out, Madam Speaker, and I am not jumping to any conclusions, but the other thing that I want to find out is, based on the answer which was given through the ministry by the Water Authority, what would cause them to make clear statements that no such equipment was available, if indeed equipment of this nature is available locally. I give an undertaking to find that out, and then certainly we'll have to deal with it afterwards. Unfortunately, I can't say any more at present, because in fact, I think just about everything is done and over with right now. So I can't undo what has been done, but I certainly intend to find out, and what we really need to do is to ensure that the agencies know what equipment is available locally. So when they're sending out their tenders, all of the local heavy equipment operators will have an opportunity to bid on whatever the project is. And that's not limited to the Water Authority, but including the Water Authority.
If there are no supplementaries, Honorable Member from Northside and then the Leader of the Opposition. Honorable Leader of the Opposition.
Through you, Madam Speaker, can the minister tell us for what period, if he's available, as to what period of time the equipment was imported for? Was it 3 months? Was it 6 months? Was it the length of time of doing the work, and whether the equipment, if the work is finished, if the equipment is still here on the island?
Honorable Minister.
Madam Speaker, all of that is being found out. But I did not know, and the answer only says that this equipment will allow the job to be finished a month ahead of schedule, if I remember correctly what I read. But as regards to the specific timing, that I do not know, but that's being found out as we speak. And what I can do is I'll undertake to give to members an answer in writing about all of these things that we just talked about, so that we will know exactly what has happened and we can make a clear determination.
Honorable Leader of the Opposition.
Thank you, Madam Speaker. Can the minister, I don't think he said it in the substantive question, what is the totality, the total amount of the contract?
Honorable Minister for Planning.
Don't know that either, Madam Speaker, but I will find that out.
The Leader of the Opposition.
Thank you, Madam Speaker, but it seems that this is a very extensive contract, so it got to be in the millions of dollars. And the minister was not informed about this process. They didn't say to the minister that in doing this contract, we have to have equipment that is not here, and so we have to allow the equipment in. He was not informed as the minister.
Honorable Minister for Infrastructure.
Madam Speaker, for the third time this morning, the answer to that is no. I was not informed before the fact. I was informed after the fact when the question was sent to the ministry, and the ministry sent it on to the Water Authority, asking them to fill us in so that we could answer the question properly.
Madam Speaker,
Honorable Leader of the Opposition.
just to say to the minister that this is the third time he's here, so I wanted to have it really solid in the answer that that does take place, not just in this administration, but in other administration, when they were on this side and somebody else was on that side too.
Member from Easton.
Thank you, Madam Speaker. Madam Speaker, first a comment to the minister, just to assist him. We have excavators in this country, from backyard excavators up to at least 2 450s that is capable of lifting. Those 450s, John Deere's, are capable of lifting up to 120,000 pounds 40 feet away from them. And at least one of them has a 6,500 pound counterweight, which doubles that almost. Anyway, Madam Speaker, I am, and then we have loaders with forklift capabilities. We have sky tracks. Madam Speaker, the minister, unfortunately, can only say what he has received. Is it not the fact that, is it so that this equipment will be sent back off the island?
Honorable Minister for Infrastructure. I think you alluded to that already.
Madam Speaker, that I did say that in the substantive answer because that's what I was informed by the authority. But I can tell the minister, the member from East End, that if the equipment hasn't left yet, it won't be long.
If there are no further supplementaries, we'll move on to the next item of business.
Statements by the honourable members and ministers of the
Madam
cabinet.
Clerk, just 1 minute, please. Sorry, my apologies. I recognize the Honorable Premier. He's now in possession of the promised answer to a supplementary. Honorable Premier. This was dealing with the conditional release law and the DCR for the benefit of members.
Thank you, Madam Speaker. Madam Speaker, on Friday, I asked leave to defer answer to a supplementary question with respect to the conditional release law because I needed to ensure that the answer that I was giving was correct. And I now have the requested information. Madam Speaker, there was a statement which I made in which I said that the conditional release law only applied to persons who were convicted since the law. That answer is not entirely correct. And when I say that, as I read, I think members will understand the reason for the confusion. Section 3.1 of the conditional release law says that the law applies to all prisoners regardless of when they were convicted or sentenced. But the difference is that it doesn't apply in the same way. Uniformly is what I mean. Prisoners serving a term of imprisonment exceeding 1 year, except those serving life, must serve 60% of their sentence before they're eligible to be considered for release by the Conditional Release Board. But prisoners sentenced prior to the onset of the Conditional Release Law and regulations remain subject to the provisions of the Prisons Law 1975, in that if their earliest date of release, as specified therein, is earlier than the date at which they would become eligible for release on license under the Conditional Release Law, the Prisons Law shall apply. However, the Conditional Release Board, as established under the Conditional Release Law, considers all cases, including those coming forward as a result of the provisions of the Prisons Law 1975. Both systems run side by side in order to ensure that all persons leaving prison have an equal opportunity to be placed on license for the purpose of community-based supervision after release from prison. As the Conditional Release Law enables the board to meet monthly, the Department of Community Rehabilitation is currently working with other stakeholder agencies, including the Prison Service, in order to prepare the following number of offenders for the board's consideration. April 2016, last month, 4 inmates. May, 6 inmates. June, 4 inmates. And July, 2 inmates. Of these 16 inmates, 1 is eligible under the Conditional Release Law, and the other 15 are eligible under the Prisons Law 1975.
Recognize the member from Easton.
Thank you, Madam Speaker. Madam Speaker, without the benefit of having the statement.
The Sarge making copies, member from Easton.
Okay. Just for the Premier to clarify, when we are saying that these two laws are running parallel, is it that we don't get in contravention? I believe at first it was 5/8, 5/9, and then this one says 60%, I believe, right? Right. Is it they are running parallel for that purpose, but not for the purpose of supervision? The supervision prior to this law coming into effect was at best ad hoc. But now that we have a actual release law, it is mandated how it will be done with the board and the supervision and the management thereof. So with those three laws, it appears the Prison Law 1975 said once, I think it's minimum periods of incarceration, I think it's on. And this one is a little different. I think it says 60%. Madam Speaker, another one with 5/9 or something. So I'm wondering if it's only that, because it still means that this one applies entirely to the supervision thereof.
Honorable Premier.
Yes, Madam Speaker, the members got it right. There are actually three different periods. There's the 5/9, there's the 1/3, and then there's the 60% now created by the Conditional Release Law. But they're all now subject, once they are actually released, they're now subject to the provisions of the Conditional Release Law with respect to their supervision, rehabilitation, and so forth.
Madam Clerk, next item.
Statements by honorable members and ministers of the cabinet.
Recognize the Honorable Minister responsible for Community Affairs.
Thank you, Madam Speaker. Madam Speaker, 1st of May 2016 marks the first day of our annual Child Month celebrations here in the Cayman Islands. Therefore, it is my honor to stand before my esteemed colleagues today in order to talk about the activities that are planned to encourage families to reconnect as well as raise awareness about the issues surrounding the safety and well-being of our children. Children, Madam Speaker, are the most precious gifts on earth, and for the month of May, we celebrate them. This is, in fact, our 20th annual Child Month, which truly shows the commitment our country has made to putting children and the issues they face at the forefront. Most admirable, Madam Speaker, 20 years for the Cayman Islands. Proverbs 22, verse 6 says, "Train a child in the way he should go, and when he is old, he will not turn from it." Madam Speaker, this verse reminds us of the critical role that both parents and the community play in shaping a child. Indeed, it sums up this year's Child Month theme, which is shaping our children's future. I believe that if we invest in and promote our children today, they will grow up to be caring, responsible people tomorrow. I stand firm in my belief that every child deserves to be protected from abuse and neglect, to be given the opportunity to develop skills to equip them for adulthood, to be involved and make positive contributions to our islands, and to be prepared to meet difficulties and uncertainties head-on so that they can reach their full potential. Hence, Madam Speaker, throughout this month-long observance, the Ministry, in partnership with the Department of Children and Family Services, will focus on the social, emotional, physical, and spiritual development of each child in our community. The Department of Children and Family Services, alongside other partnering agencies, will host a variety of events in celebration of Child Month, with a focus on the important role the family and extended community play in ensuring these outcomes are a reality for our future. I've asked, Madam Speaker, that when the members receive this copy, that the month's calendar of events be attached to it as well for the assistance to members. Madam Speaker, a strong emphasis will also be placed on child protection with a special panel discussion set to air on CIG TV. Other events include a prayer breakfast that will offer spiritual guidance for children and families. There will also be activities such as games and movie night, sure to bring out the child in each of us. Madam Speaker, the work of raising a child does not lie in the hands of parents alone. It takes a village. When I think back to my own early years, the whole community, including parents, grandparents, aunts, uncles, and neighbors, took part in child rearing. So let us take a cue from yesteryear and make a pledge to have everyone in the community step up and do their part in shaping the future generation. Together, we can continue to strengthen and, where necessary, support families. Finally, Madam Speaker, as Child Month begins, let us once again express our appreciation for God's most precious gifts and honor our future leaders today, tomorrow, and for many years to come. Thank you, Madam Speaker.
Personal explanations,
None.
obituaries and other ceremonial speeches,
None.
raising of matter of privileges,
None.
government business, bills, second readings, the Standard and Public Life Amendment Bill 2016.
Recognize the Honorable Deputy Governor. Oh, I beg your pardon, that was my information. I recognize the Honorable Premier. Order.
Thank you, Madam Speaker. Madam Speaker, I beg to move a bill for a law to amend the Standards in Public Life Law 2014, Law 3 of 2014, to clarify the extent to which a person in public life is required to declare matters that relate to other persons and for incidental and connected purposes, shortly entitled the Standards in Public Life Amendment Bill 2016.
The bill has been duly moved. Does the Honorable Premier wish to speak to the bill?
Yes, thank you, Madam Speaker. Madam Speaker, the bill which I have just moved seeks to make amendments to the Standards in Public Life Law 2014, which was passed by the Legislative Assembly on the 31st of January 2014. Madam Speaker, the law has still not been brought into effect, principally because of concerns expressed by members of the public who serve on government boards, commissions, committees, and so on. These concerns surround the content of the declarations as it relates to connected persons, specifically the inclusion of employees, as this was regarded by many of those persons whom we rely upon in our system of government administration to serve on boards, committees, statutory authorities, as being too broad. The requirement to declare membership in associations and organizations, and the lack of clarity in what circumstances a member of a board, committee, etc., must include content in their declaration. As such, the Standards in Public Life Amendment Bill 2016 seeks to amend the Standards in Public Life Law 2014 in order to clarify details about who is required to file a declaration and what those persons are required to declare. The amendments include the definition of connected persons to now include those persons in the declarant's immediate family and remove the reference to any employees of the declarant. This amendment serves to ensure the concerns expressed by members of boards, commissions, committees, and others concerned that they would have to include in their declarations information relating to their employees are alleviated. The required details provided by a person in public life when filing their declaration. Persons in public life will now only provide details relating to themselves and any member of their immediate family. This is changed from the requirement to provide details relating to themselves and any connected person, and has also led to the inclusion of a definition of the term immediate family in the bill. Immediate family means a spouse, a dependent, or such other person as may be prescribed by Cabinet by regulations. A clarification that a person in public life now only provides details in a declaration related to a connected person when they hold property or manage anything on behalf of a connected person, or if a connected person holds property or manages anything on their behalf. A clarification that as persons in public life, members of boards, commissions, committees, and such will complete declaration forms annually. However, they will only need to include in a declaration any interests, income, assets, and liabilities where there is a possible or perceived conflict with their functions on the entity to which they are appointed. Any question regarding a possible or perceived conflict shall be determined by the Commission. This means that persons in public life who serve on different boards, commissions, committees, etc., will be required to complete separate declarations which may provide different information depending on the board or commission they're on and whatever businesses or interests they may have which have the potential to conflict with their duties on that board or commission as the case may be. The deleting of the requirement any person in public life requirement for any person in public life to declare their connection with any political, trade, professional, fraternal, or charitable organization, registered or unregistered. Madam Speaker, other sections have been amended to ensure clarification, such as the ability of members of the public to inspect the register during normal working hours, the retention of the power of the governor to appoint persons to those boards, committees, etc., which fall under her purview, as set out in Section 55 of the Constitution, the provision of flexibility to Cabinet to determine the initial terms of appointments of persons to boards, as the current law allows them during the reappointment process, and the protection of parliamentary privilege. Madam Speaker, I look forward to receiving the support of members of this Honorable House for the proposed amendments and look forward to the debate. Thank you, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak? Last call. Does any other member wish to speak or recognize a member from East End?
Thank you, Madam Speaker. Madam Speaker, to say that I'm confused is an understatement. Because when we did this bill, 2014, I think it was, in my memory, may have faded in some places here, but I recall us at the time talking about the extent to which someone serving would have to declare interests and the likes, perceive interests, and that the complaint was that people were talking about their employees and they have no control over their employees in their private life. And I see where now the government has taken that out. But I also see where there will be no requirement to declare any of that interest unless it's perceived. Now, the public life, not us yet, board members and the likes. Now, with the definition of connected person having been changed now to, pardon me? Yeah, it's more limited. Removing employee at least, and inserting a member of the immediate family. And then immediate family being defined as a spouse or a dependent. Now, Madam Speaker, my argument was then that whilst there may be some need to consider removing employees because of from people who would go on boards, that was not the end and all. I believe that most people would have been satisfied with it not being made public, a public document, because we are now saying that upon application by any member of the public, they may inspect the register. Um, I believe that most people were, while they were concerned about their employees, and I think we had made um, reference to some people who were in construction industry and on planning board and wouldn't know what they, or suppliers of construction material, and wouldn't know what their employees were doing. So we were pressing the envelope, to say the least, to try and expect people to have control over their employees as well. But I believe, having said that, I believe that people were more concerned about these things being made public. Now, we have gone to the extreme of saying that if it is not perceived as a conflict with that particular board, that or position that they hold, then they need not do it. Madam Speaker, that runs counter to what I believe us in public life should be, what we need to be, because it doesn't necessarily mean that your interests are not elsewhere, and because of your position on that particular board, it can be influenced. That's where I tend to diverge from what the government is doing. Because, Madam Speaker, then when it comes to the MLAs, we are required to do all of it. Yes, we are influential in all aspects of all boards and all walks of life, and we are required to do it. And I don't try to stop that or defend or object thereto. But, Madam Speaker, certainly a public officer, which would include civil servants and the likes, would still be, if it's not perceived, then you don't have to do it. That runs counter, in my view, to what being a conflict of interest really means, especially if you're in public life. I have my concerns about that. The fact that, Madam Speaker, we are going to run ourselves in problems in that regard, because, and Madam Speaker, a simple example. For us to find we are of limited human resources and knowledge, and abilities when it comes to specific things. Let's look at the financial industry. And what you want is someone who has had knowledge in that financial industry, and to go on SEMA. And that must be perceived. So what do we do? How do we find someone to go on SEMA? How do we find someone? I understand declaring their interests, but no, and I understand that it doesn't mean they can't go. It would mean that we don't qualify for the Legislative Assembly too, if it exactly, I totally agree with that. But in the same token, I don't have a problem with people declaring it. I'm just wondering if it's absolutely necessary for it to be a public knowledge. Now, if the commission keeps it, and if the subject arises, then it is available. that is where I sort to go a little, take divergent paths from what this is, because I'm sure people are prepared to do that. And I'm not saying you're not got to declare it, but don't make it a public declaration is on, with these people on the boards. With MLAs, yes. With civil servants, I totally agree. It needs to be up on websites. In this day and age of technology, I have called for the register of interest here in the Legislative Assembly to be made public, instead of coming in here and someone has to go in the back room and someone is watching you like a hawk over it, that you don't take anything, or you don't take pictures, or you don't take copies of it. What is wrong with putting it up on the website, that all and sundry can see it? You had no business coming in politics. Nobody holding a gun to your head. Get out. Get out. That's my view. Yeah, but are coming to us, old cousin. No, I call you cousin. Everyone else but you. I can't call front. Madam Speaker, I shall resist.
The response or the love?
I must respond to love. You never heard that song by Tina Turner? What's love got to do with it? Madam Speaker, I don't mean to be disruptive, but I then look at Section 33. Would you follow me, please? There are more laws here than a Philadelphia lawyer. Madam Speaker, under Part 7, the members of the Legislative Assembly, which I questioned at the time as well. Where a member contravenes this law, such contravention may constitute contempt of the Legislative Assembly, for which the Assembly may order the member's suspension from sitting and voting in the Assembly for such period as the Assembly may determine. Madam Speaker, at the time when this was done, I questioned that as to why that had to be put into law. Because immediately we're talking about suspension, and we may suspend. There are very seldom has privileges been encroached upon under the Westminster system that we have ever done that. There is no need to put it there, because we have a committee here, an ethics committee, who will hear that. And the legislature, under the leadership of the chair, will determine what penalties are applied. And Madam Speaker, I'm a student of Erskine May as well, and you will find that it has been sparingly used. Apologies or the punishment, public apologies or apologies to the legislature, House of Commons, are more acceptable. I know the immunities and privileges law needs to be updated as well, Madam Speaker. That is in woeful need of update. But certainly, I didn't see any need then to repeat it in there, but I can see things being said in the law, like it shall be dealt with under the immunities and privileges law or something of that nature, which has a committee. The legislature has a committee to deal with that. It sends the wrong message here that that is the only means of penalty that can be meted out by this legislature. Because what we do is say that we can't make mandatory stuff. And I know it says may, Mr. Premier, but it's in the wrong place. If you want to know what kind of penalties for conflicts and contraventions of the laws in this country as a member of Parliament and under the rules of this legislature, then you need only look at the privileges law. And this one, no, it may constitute. And it's, Madam Speaker, it's really not the Assembly that does it. It's a committee of the Assembly that does that. Well, I guess. No, we have a standing committee that deals with ethics. But that's true, we need to vote on it, don't we? You're correct. Well, Madam Speaker, I have my own concerns about that. But then, Madam Speaker, where I do have further concerns is, I think it's 12, where 13, where members of the Legislative Assembly has to declare for their dependents, interests and the likes for their dependents. I don't know why that is. I can understand spouse, because all companies that I know, especially those in the business of where there may be conflicts and in compliance with laws of a country, it extends to spouses. Time for him get out now at 24. Yeah, well, I understand, Madam Speaker, that I think the insurance law, it says 23 or until school is over or something of that nature. But that dictates school, that the child is still in school, and there should be really no conflicts there. Now, if as a dependent, I don't know, and it would be interesting to hear what the intent of dependents declaring anything that they may have. I can't comprehend how that would work. And if the Attorney General has anything to enlighten us with that, then I would be more than happy to. Because, Madam Speaker, the obvious thing is, if you have bought a little piece of land or something, I don't know if you can, a dependent under the age of 18 can even, that can be in their names even. It has to be in trust, yeah. In some way, or your name is on it, or will to them or something of that nature. prior, and then when they become 18, because I know it happened to me. When I bought shares, when I was given shares into CUC, I put my two children as the beneficiaries. At the time, I still had control, but now they're over 18. Poor old Arden getting knocked right out that, because it's no longer a dependent, it's theirs now. So if it would be interesting to hear how the Attorney General or the Premier explains those few areas that I had my concern. And Madam Speaker, I still don't see why everything, we don't trust ourselves, or we're afraid that we gonna have conflicts. Governor this and the governor that and the governor that. And, yeah, but on their responsibility, yeah, but it's still the appointment of other stuff has to still be done by the governor. Who appoints the boards? I know cabinet appoints the boards, but I don't know. Yeah, we gotta operate, but we can press the envelope a little bit too. It is time now that we take up some responsibility instead of blaming everybody else for what we are supposed to do. I don't know how we are going to slowly take over our country or speedily, I don't know. But anyway, Madam Speaker, those few things, if the Premier would satisfy my curiosity on it, I would be most grateful.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak or recognize the Honorable Attorney General?
Madam Speaker, just a very brief intervention, if you will. The honourable member spoke about clause 9, which deals with section 33 and the issue of contempt, sanction of contempt, where a member is found to have in breach of the law. The whole idea here, Madam Speaker, is that initially the law says shall, and it was recognized that the use of the mandatory term shall was in fact encroaching on the privileges of this House. So it might very well be that there's an allegation that there was a breach. There's a breach of the standard in public life law, but it still falls to this House to make that determination as to, in fact, whether or not the person is in fact guilty of such breaches. Yeah, that's right. And having found that it constitutes a contempt, the House may do one of two things. But of course, the extreme is to order a suspension. But certainly, the House is entitled to impose a lesser sanction on the member. So it doesn't, because it says that it may suspend the member, it doesn't follow, Madam Speaker, that's the only option that is open to the House, that is suspension. Lesser penalties might be employed. Madam Speaker, I think the honourable member, I'm not so sure whether he missed the point about the perceived conflict. that is section 12 of the bill, which shall not be required to include a declaration of any interest referred to in the prescribed under subsection 1 unless there's a possible or perceived conflict. Madam Speaker, the language there has always been the same. We're not changing that. It has always been whether there's a perception of a conflict. So this bill hasn't changed that really. All the bill did, or as it's doing really, is to restrict, if you will. Yeah, well, no, the word interest is in the Constitution. We just lift the language from the Constitution. So that's where the word interest comes into. So. So hopefully I've been able to clarify that for the honorable member. Okay. And then the other point you mentioned was, what's the other point?
Is this the appropriate time for the luncheon break? We'll now take the luncheon break and reconvene at 2:30 p.m.